The Trump administration has officially responded in the Supreme Court case surrounding Missouri's Second Amendment Preservation Act, or SAPA. Their latest filing adds a new twist. On one hand, they argue the law is invalid and urge the court not to review it, but on the other hand, they say they're willing to drop parts of the case once it's back in the hands of the lower courts. It's a surprising move that deserves a closer look, especially given how important this case is for gun rights and state sovereignty. But before we get into the details, if you appreciate content like this that breaks down real 2A legal battles in a way you can follow, please consider subscribing to the channel. It's completely free and helps the channel grow. And if you find this update helpful, drop a quick comment down below. It could be something as simple as, "Thanks for the update." It really helps push this information out to more people who care about their rights. 1. The SAPA case background and Supreme Court involvement. This case revolves around Missouri's Second Amendment Preservation Act, passed in 2021. The SAPA law was designed to protect gun rights by blocking Missouri's state and local officials from helping enforce federal gun regulations that the state believes violate the Second Amendment. In short, Missouri told its officers, "You won't assist the federal government in enforcing laws we believe are unconstitutional." The law even allowed private Missouri residents to sue state officials who violated that rule. That gave real enforcement power to the people, allowing them to hold their own government accountable if it helped enforce federal gun control measures seen as unconstitutional. But the federal government pushed back. Under the Biden administration, the Department of Justice challenged the SAPA law in court. The district court eventually struck down the law in full, wiping out all of its provisions. Missouri then appealed that decision to the Eighth Circuit and requested an emergency stay to prevent the ruling from taking effect while the case moved forward. That emergency request ultimately made its way up to the Supreme Court. The Supreme Court responded with an 8-1 decision, denying Missouri's request for a temporary stay. That meant the lower court's decision striking down SAPA would stand, at least for now, while the justices considered whether to take up the case formally. Till the Trump administration's new filing. Now fast forward to today. After months of delay, the Trump administration has filed its response in the case. Interestingly, they agree with the Biden administration's position on some key points. They argue that SAPA, as written, is invalid in how it interferes with federal law. Because of that, they've asked the Supreme Court to deny Missouri's petition and avoid taking the case up for full review. But here's where it gets interesting. Even though they oppose SAPA, the Trump legal team says that once the case returns to the lower courts, the federal government will voluntarily drop part of the judgment. That would partially reverse the total wipeout of SAPA and resolve some of the outstanding legal issues at the lower court level. So, while they're opposing the law in principle, they're also signaling that they don't want to continue pressing for such a sweeping decision against it. That dual message has left many observers puzzled, and it raises bigger questions about how future Second Amendment and states' rights cases could be handled. After the Eighth Circuit regained control of the case, it proceeded with oral arguments. However, the outcome remained unchanged. They once again ruled in favor of the Biden administration. In response, Missouri filed a writ of certiorari, asking the U.S. Supreme Court to review the case on its full merits. In their petition, Missouri emphasized a critical issue. The Eighth Circuit acknowledged that the structure and potential operation of the Second Amendment Preservation Act, SAPA, could be lawful, yet the court still struck down the law based on what it believed was its underlying purpose, to protect Second Amendment rights. Missouri argues this reasoning is flawed and represents a departure from legal precedent. Another major argument from Missouri is that the Eighth Circuit wrongly allowed state officials to be sued. The court concluded that by choosing not to enforce federal gun laws, Missouri officials were somehow still enforcing something, effectively claiming that non-enforcement is a form of enforcement. Missouri strongly disagrees with this logic and believes it misinterprets the state's actual conduct under SAPA. Originally, it was the Biden administration challenging the law, but after the change in presidential administration, the Trump administration took over the case. For months, they delayed filing a response in the Supreme Court, reportedly to reassess their approach. Eventually, they filed their brief maintaining that SAPA is unconstitutional in most of its applications and that the lower court's decision was legally sound. They urged the Supreme Court to decline Missouri's request for review. At the same time, however, the Trump administration's legal team introduced a new stance. They stated that if the Supreme Court denies review and the case returns to the district court, they would support narrowing the scope of the judgment. In other words, the federal government would voluntarily give up parts of its earlier legal win, acknowledging that some aspects of the lower court's ruling may have been too broad. In their response, they rejected Missouri's claims that the federal government lacked standing or a valid cause of action. They argued the United States clearly has the authority to challenge the law, since SAPA directly discriminates against federal officials and obstructs the enforcement of federal laws, issues that fall under the Supremacy Clause of the Constitution. Still, they conceded that certain provisions of SAPA raised more complex constitutional questions than the Eighth Circuit recognized. They also expressed concerns that the judgment issued by the lower court might have gone too far, especially in areas where SAPA simply reflects a choice not to assist in federal enforcement, something that may be protected by the anti-commandeering doctrine. They noted the uncertainty about how these provisions would be enforced and whether they are separable from the rest of the law. As a result, the Trump administration said that once the district court regains jurisdiction, it would not oppose a motion from Missouri, filed under Rule 60B, to reduce the scope of the original ruling. The federal government would agree to drop parts of the judgment, except those provisions that directly apply to federal authorities or interfere with federal law enforcement. That's where the federal government currently stands. Although they argue that Missouri's legal arguments are incorrect and the SAPA law remains unconstitutional in part, they are now willing to scale back their position and limit the scope of the judgment. After delaying their response for several months, the Trump administration has now officially weighed in. They've maintained that certain aspects of the SAPA law remain unconstitutional, and that the lower court was correct in blocking some of those provisions. They're also urging the Supreme Court not to take up the case at this time. However, in an important shift, the administration is also acknowledging that the lower court may have gone too far by issuing such a broad, pre-enforcement injunction that struck down the entire SAPA law. They're now indicating that once the case is back before the district court, the federal government intends to release part of the original judgment. In other words, they're backing away from seeking a complete block on SAPA. They're prepared to concede some portions of the law, recognizing that not every part of SAPA may violate the Constitution. This strategy gives the Supreme Court a relatively simple way to avoid directly ruling on the case. With the administration signaling a willingness to scale back the judgment, the justices may choose to send the case back to the lower court, where both sides can continue to dispute the specific scope of what should and shouldn't be enforced. It's a practical off-ramp that allows the Supreme Court to sidestep a potentially broad ruling. The Trump administration has clearly stated that while they still take issue with certain parts of the law, they no longer support a full pre-enforcement block. Once the district court regains jurisdiction, the federal government won't oppose a motion from Missouri to limit the scope of the original ruling. From there, the litigation will likely shift back to focus on which provisions of SAPA can stand and which cannot. This development creates a very real possibility that the Supreme Court might decline to hear the case altogether, especially since the parties now appear to be headed toward further resolution in the lower court. The entire case centers around state-level Second Amendment protections and whether federal law can override them. So what happens here will set a significant precedent moving forward. We'll continue tracking this closely as the situation unfolds. As soon as there are updates, whether from the Supreme Court or the lower court, we'll bring them to you. If you found this breakdown helpful, don't forget to like, leave a comment, and subscribe to stay informed on major legal battles like this one. Thanks for watching.